materials for execution of the works. And in fact, one of the works had been executed, and though it was not yet completed. Lordship,
Where is the work order?
the work order is at page 22, Your Lordship.
Huh?
Page
22.
22. There are two work orders, Your Lordship, 22 and 25. It's dated 12 January 2026. Both of them are of the same date. It's for construction of water tank at Wayme Ram near Gauhati Center.
Okay,
Center 2.
we'll issue notice at this stage.
Lordship. In fact, Lordship, since the works have been started, Lordship, we have sought for interim relief at this stage. Respondents may not issue
Did
any
this
work
court pass
order.
any interim orders on the earlier cases?
Yes,
Can
interim
I have a
orders.
copy of them?
Lordship.
Who appears for the respondents? Yes, sir. What do you say?
Two respondents also.
Any reasons for cancelling the work?
Lordship, in fact, yes, the same order may be passed as of now. In the previous cases, even though we are almost finished the affidavit, but new cases have come up, so we are waiting for a bit. I may be finished the affidavit within
Here
2
we
weeks.
don't have a decision of the. Where is the first stay order? Sufficient.
Lordship, I have given the list of analogous writ petitions. As of now, 10 writ petitions of analogous nature have been filed.
Okay. But Mr. You're appearing in this matter? C. Lalram Zoba, senior advocate, learned senior advocate, assisted by. Take her name, so and so, appearing for the petitioners. Full stop. The grievance in this writ petition is against the orders dated 5th of May 2026. By which all work orders issued by the Aizawl Municipal Corporation based on the first installment fund of the 15th Finance Commission Grant 2024-2025 were kept in abeyance, irrespective of whether the works had started or not. Full stop. By another order dated 27th of May 2026. The municipal commissioner had directed the petitioner number 1 had informed the petitioner number 1 that the work order issued to him with regard to the construction of water tank at YMA Ram near Anganwadi Center 2 at
Lordship, that 2 is to be read as 1 because it is a mistake on the part of the, I have stated in my petition also, that's to be construed as 1.
No, page 33 and 34 both say 1.
Yes.
2,
yes,
both say 2.
2. Yes, it is 2, but since the
Okay.
location,
Anganwadi Center 2 at Republic Venklung dash wide work order amount of rupees 15 lakhs stood cancelled immediately in public interest. Full stop. The learned senior counsel has submitted that the location of the work is near Anganwadi Center 1
yes.
and not at Center 2, and there appears to be a typographical error in the order dated 27th of May 2026. By the order by another order dated 5th of June 2026, comma, the petitioner number 2 had also been informed that the work order for widening of road near H. Kaplira Mual Vengchung to Veterinary Complex Approach Road at Republic Veng also stood cancelled. Full stop. The learned senior counsel has submitted that similar cancellation of work orders are pending adjudication before this court in several writ petitions, some of them being WPC 81 of 2026, 88 of 2026 and 89 of 2026. Full stop. The learned senior counsel has submitted that at this stage, if the respondent authorities are allowed to allot the work order to some other party, irreparable loss would be caused to the petitioner's hearing, and it would be in the interest of justice to restrain the respondent authorities from allotting the work orders to any other parties. Mr. Swenson counsel appears for respondent number 1 and 2 and has submitted that he would have his instructions and would also file the affidavit in opposition within a period of
2 weeks.
2 weeks from today. Full stop. Issue notice. Since the respondents are represented, no formal steps are required. However, extra copies of the writ petition to be served upon the learned counsel appearing for the respondent number 1 and 2 within a period of 2 days from today. Stop. Respondents should be at liberty to file their affidavit in opposition before the next date of listing. Stop. In the interim, it is provided that the respondent authorities shall not allot the works in issue in this writ petition, namely, number 1, you will take it from that, construction of so and so, and I have flagged it in blue and I'm underlining it. There will be two work orders. What I have underlined is what you write. At page 33 and at page 35, I have underlined. To any other person without leave of this court. List again along with the WPC number 81 of 2026 and other connected matters. Any idea when they are supposed to be listed, sir? Any next date of listing given?
That's it. 13/8. 13/8.
13/8.
Yes.
13, 1-3.
1/3.
It seems to be too early, my lordship. Maybe at least
Today
2
we
weeks,
are at,
commencing from
today
today.
we are on 4th.
18, 19, lordship.
No, it'll be listed along with them. They are connected matters, is it not? The same issue would arise.
I'll be filing affidavit altogether, lordship.
There's no difficulty. On 13th, when the other matters come up, tell us. Whatever affidavits you are ready to file, file them. In cases where you need to file, need some more time, we'll consider on 13th. Will that do?
When is your lordship 17?
But then what about the other cases?
Lordship,
Again, on the
13/8 is the date fix
There is already
in
date fixed.
all other
That
cases.
in other cases, okay.
Date
Lordship,
is
fine.
already
It's
fixed.
all right.
Date
It's
is
all
already
right.
fixed.
Sorry, lordship.
List on the 13th of August,
Sorry, lordship.
2026, along with WPC number, so and so. One of 2026 and other connect.
No, please.
Item number 2.
Yes, madam.
Yes, may please, your lordship. I am here for the petitioner, lordship. And as per the last order dated 8/5/2026, lordship, the respondent number 6 and 7 have to file the affidavit, but till today.
Your Lordship, I have received instructions if I may be granted 2 weeks' time to file the affidavit on behalf of the state respondent.
Ms. So-and-so appears for the petitioner. Ms. So-and-so, you are appearing for?
State respondents, Your Lordship, 6 and 7.
For the respondent number 6 and 7. Prays for 2 weeks' time to file affidavit on behalf of the respondent number 6 and 7, full stop. It is noticed that the respondent number 6 and 7 had an earlier occasion also sought for time to file affidavit, full stop. Respondent number 3 and 4 have already submitted their affidavit, full stop. Respondent number 1 and 2 have submitted that they would not be filing affidavits, allowing one further opportunity to respondent number 6 and 7 to bring their response on record, list the matter again on.
Your Lordship, if the matter may be listed on the 18th, Your Lordship.
18th of August 2026.
Much obliged, Your Lordship.
Item number 3.
Yes, sir.
Your Lordship, office note would indicate that ID card has returned in respect of all the respondents. So notice has to, is to be completed.
Lordship, I'm appearing on behalf of respondent number 1.
You don't want to respond? Huh?
No, Lordship.
We can allow it. What is your ground of challenge?
Your Lordship, before the tribunal, their main basis for filing the claim is based on the police report that there was an accident. Now the police report was made after 1 month of the accident. And the police who had made the report was not made a witness at all. So we don't know if it's genuine or not. Only the claimant herself was made a claimant witness. Only the claimant was a witness. One witness only. To prove their entire case. Why the police was not? Because the claim was made on the basis of a police report. So that's the basic thing which they have to prove. The independent witness was not examined at all. So how can the tribunal make a judgment and order based without any third-party evidence, independent witness? That's the main ground, Your Lordship. Because the accident which they alleged happened, that basic thing has to be proved, Your Lordship. The claimant, who was not there at the time of the accident, who is a sister of the deceased, how can a statement be taken as a gospel truth for making a judgment, Your Lordship?
You had conducted your own investigation.
We have conducted our own
You
investigation.
did not bring that on record to show that there was no accident. Whatever is not controverted is deemed to be admitted. Yes. When will you file your reply? Ms. So-and-so, Learned Counsel, appearing for the respondent number 1. Praise for?
I'm for respondent number 1, Lordship.
Praise for
2 weeks, Lordship.
2 weeks time to do what?
If we are going to file any reply or not.
To file their objections, to file their response. List again on 18th of August 2026.
Your Lordship, if the notice may be deemed to be completed.
On
Your Lordship, the office note indicates that ID card, signed ID card has returned from respondent number 2 and 3 also. So notice is completed, Your Lordship, if that may be reflected in the order.
earlier office notes of 18/6/2026 and 19/6/2026 reflect that the postal consignment tracking revealed that notices were delivered to the respondent number 2 and 3. And in respect of respondent number 3, duly signed AD cards have also been received. Full stop. Accordingly, notice on the respondent number 2 and 3 are deemed to be complete.
Obliged.
The said respondents would be at liberty to file their response to the appeal before the next day fixed. Yes.
Item number 4.
Your Lordship, I'm appearing on behalf of Mr. Caesar Ramchana, the senior counsel. Unfortunately, my lord, he's now hospitalized. He has met with an accident on Sunday. He's now in HDU, so if the matter may come after 2 weeks.
Yes, madam.
Yes, Your Lordship, if we may accommodate the learned senior counsel, and
No.
if this matter will be listed.
Today you are supposed to do something. He has got nothing more to do.
Yes, Your Lordship, but
You had said that since the petitioner does not question the requirement of acquisition, he will not be entitled to compensation.
yes, Your
We
Lordship.
wanted to know what sort of a law is that.
Yes, Your Lordship. Your Lordship, my apologies, Your Lordship. Today I was not prepared because since the learned senior counsel will not be here.
But we are keeping it as a part-heard matter on the last occasion.
Yes, Your Lordship.
If you take too much of time, then we'll have to release it from part-heard. How much time do you want, sir?
2 weeks' time. 2 weeks.
It is submitted by Mr. So-and-so, learned counsel appearing for the petitioner, that the learned senior counsel appearing for the petitioner is not in a position to attend the proceedings today. Full stop. The learned counsel appearing for the respondents has given a consent for for refixing of the case. Stop. By order dated 2/7/2026, the matter had been kept as part-heard, requiring the learned counsel for the respondent to address the court on the submission recorded in the order dated 2/7/2026 itself. Full stop. At the consent of the counsel for the parties, list this matter again on the. You want me to release it from part-heard so that you can take it up with someone else, or? At the consent of the learned counsel for the parties, list this matter again after 2 weeks on a date to be fixed by the registry. Full stop. The matter shall not be treated as part-heard. Next.
Item number 5.
May it please Your Lordship, I am appearing on behalf of the state respondents number 1 to 3. Your Lordship, I have filed the written objection to the IAs yesterday, and it might not have reached the court, Your Lordship. And if I may, Your Lordship, since these are analogous cases, there are supposed to be 5 RFAs, and 2 of them are listed here, and the other 2 are listed in Justice Habung's court, Your Lordship. So if
Today?
yes, Your Lordship. However, if there, since they're analogous cases, Your Lordship, if I may be allowed to pray that the matter, all the 5 matters be listed in one court, Your Lordship, for final hearing to be fixed on
Or we
the
can say that you have Ms. So-and-so in counsel appearing for the respondent number.
1 to 3, Your Lordship.
For the respondent number 1 to 3 has submitted that the respondents have submitted their response to the interlocutory application
Yes, Your Lordship.
yesterday. Full stop. The same is not found on record. Full stop. She has further submitted that there are analogous matters
Yes, Your Lordship.
being RFA number being
RFA 47 to 51, Your Lordship.
51 in 51 full stop. Registry to trace out the objections filed and list these matters along with along with RFA number
7 to 51, Your Lordship.
40. This is 47.
Yes, Your Lordship. However, they have fixed this.
RFA 48 of 2025 and
Yes, Your
other
Lordship.
connected matters.
Yes, Your Lordship. And Your Lordship, if the matter may be fixed for hearing on the IA will be fixed for hearing on the 11th, Your Lordship.
11th of August.
Yes, Your Lordship.
Whether the other court is fixing it on 11th of August.
Your Lordship, that is my request that if if all the analogous may be.
That is a senior court. We'll have to wait for his orders to find out what is the date.
Yes, Your Lordship.
So I've said list this along with the other cases.
Yes, Your Lordship.
Whenever those are on list, this will also come out.
Yes, Your Lordship. Much obliged, Your Lordship.
Item number 6.
Same order. 51 is here. Same order. You have filed your objections here also.
Yes, Your Lordship.
Order, huh?
Item number 7.
It is not only the arresting authority, but it is the court also which has to give the grounds of
adjournment. My lord, fairly speaking, my lord, I am told that the counsel for the NCB has met an accident and he's in the ICU, something, I have heard it from some colleagues at the bar. So in that case, my lord,
what was the any orders earlier passed here? With TCR, has the TCR come? Scan copy, no? We'll have to wait for some time.
Actually, yesterday he made an accident. Yes. Yeah. But I think he will recover soon. Not
We'll post it, we'll try to post it next week.
next week.
Or should we give him 1 or 2 weeks more?
But let it be after a week. In the event he recovers, I'll make a mention and get it listed. Let us not fix a date here because the counsel is in ICU, I'm told, my lord. Otherwise, it will be a redundant exercise again fixing and.
It's been submitted that the learned counsel appearing for the learned senior counsel appearing for the respondents has met with a road traffic accident and is unable to appear before the court today. Mr. M. Biswas, learned counsel appearing for the petition, has requested the matter to be fixed, to be listed after a week. This matter after a week. After a week, full stop. Petitioner would be at liberty to make a mention.
Item number 8.
May I seek your lordship accommodation in adjourning the matter till Thursday, my lord. If your lordship permits, the matter may be taken up this Thursday because I have a personal difficulty today. Lord.
Yes, madam.
All right, my lord, Thursday.
What is this about?
My lord, this is an appeal filed by the state against an order of discharge by the learned court, special court in DPS.
What is the IA for?
IA is for delay.
I
my
is
lord.
for delay, my lord.
There's 56 days delay.
Are you seriously objecting to 56
Yes,
days
my
delay?
lord. Besides objecting, my lord, this petition, my lord, because I have certain doubts which I
No, criminal petition on merits,
Yes.
that is another issue.
Yes, yes, yes. But,
The-
before trying this IA also, my lord, I have certain doubts because in the lower court, there are 4 accused, my lord, who are discharged on the same grounds by the same similar order which they have appealed against here. But now, accused respondents are only 3. The states have dropped 1 accused without explaining any reason whatsoever, my lord.
At the request of the learned counsel, appearing for the respondent number 1, 2, and 3. You are appearing for?
True, as a legal aid counsel, my lord.
For 1, you are appearing for 1.
1 and 3, my lord.
1 and 3. And with the consent of the learned PP, let's just matters again on Thursday is 6th of August 2026.
Deeply applies, my lord.
Item number 9.
None appears for the respondents on call. Although,
Your Lordship, I'm appearing on behalf of the petitioner.
Ah,
I'm appearing on
although-
behalf of my senior, Miss H. Lerma Somi. H. Lerma Somi. She's the conducting counsel and she's on legs in courtroom 1.
has
Your
appeared on
Lordship.
the behalf of the respondent number 1 and 2.
Your Lordship,
Although the duly signed AD cards from both the respondents had been received by the registry, full stop. On 18/6/2026, the matter, no, the case was adjourned. In the interest of justice, giving an opportunity for the respondents to appear, full stop. None has appeared today, full stop. Ms. So-and-so appears on behalf of
Miss
the
H.
learned
Lerma
counsel for the
Somi.
petition applicant. And has referred to the contents of paragraph 1 within bracket small roman 1, small roman 2, small roman 3, four and 5, 3, 4, and 5, to submit that the delay in preferring the present CRP was beyond the control of the applicant, and therefore the same may be condoned, full stop. Considering the reasons given, I deem it fit and proper to condone the delay of 63 days in preparing the connected CRP, full stop. Accordingly, the delay is condoned. Interlocutory application stands disposed of. The registry shall list the connected CRP on its turn. IA has been allowed.
Yes, Your Lordship, obliged.
For hearing, item number 4.
Your Lordship should recall that pension matter. Manoj, it may be kindly passed over. The government advocate, Manoj, I believe she's on.
What was the matter about? I forget.
Your Lordships, we are claiming pension today, my lords, family pension and the retirement benefits of our father, who was an ex-employee, my lords. There was a disciplinary proceeding. It culminated into an order. Your Lordship said, what kind of disciplinary order is this? But since he had also, my lords, there was an admission
in a way, my lords, he did not oppose and object the disciplinary order. And basically, we are only raising one question, my lords. Can there be withholding of pension posthumously?
Posthumously,
My lords. Because the disciplinary order was to the effect of, my lords, apart from your lordship's observance.
Where is that order, his disciplinary authority order?
Page 117, if I'm not wrong. Typed order is at my lords page 119. My lords, Soila.
Yes, Your Lordship,
Oh,
if this
very
matter
good,
may
yes.
be listed after lunch at 2 o'clock.
Today?
Yes, because the calculation which they have made, I received only this morning, and I
No,
need
we'll have it
some
day after
time
tomorrow.
My lords.
to
Are
print
you
it
here?
out.
My lords, will make.
Day after tomorrow, madam?
Yes, Your Lordship.
Because today we will not be here after 2, we have got some other official work.
My lords.
Tomorrow is again a DB, we do
Yes.
not know what time we'll be free.
My lords.
Keep it on Thursday.
Thursday.
Basic issue was there was some recovery against the
Yes.
deceased employee. There was a reduction in
Pay.
his pay scale. That recovery, before it could be affected, the person expires. Now can any recovery be
No,
made?
my lords, the recovery was being made
Oh.
from my pay.
Hmm.
But there was nothing insofar as the pension and retirement benefits.
And they did not allow you the pensionary benefit.
Yes.
Why is it not being allowed?
Your Lordship, we will make clear that things when the calculation came out.
Huh?
And we can see on which head the deduction have been made. It
Your
will be
lordship
clear.
had said, my lords, fairly that we did not, since the petitioner in his lifetime did not object, but your lordships had observed that the punishment order itself is intrinsically
He
bad.
was supposed to recover it from you as per the order. You are not supposed to recover it from him. Huh?
That order has not been challenged till now, you know.
So they'll recover it from you now.
If they made a challenge of that, so we can.
It is
think
not
about that.
it is not a matter of challenging that order. It was upon you to review the order to say that we should recover. Huh? Why should he challenge? He is allowed to recover.
Given the still stands.
Obliged, my lord.
Yes. Anyway.
Item
List
number
again on
5.
Thursday, huh? List again on Thursday.
May it please your lordship, I'm appearing on behalf of respondent number 1. It seems the appellant, the counsel for the appellant is not present today, your lordship.
My lord, I am for the respondent number 2.
This is in the part 2 list.
This is an appeal.
It is
It's
in
an
the
appeal, yes.
part 2 list.
Part 2 list, yes, your lordship.
Okay, we don't pass any orders. Let it come up tomorrow day after whenever. Any more matters? Any more part 2 matters?
Item 6.
Unfortunately, the learned PP is not here.
They will come when they are to come. Are you prepared? Prepared?
Yes, prepare my
Huh?
lords.
What is the matter about?
My
Tell
lords,
us.
the present appeal is against the impugned judgment and order dated 17/9 and 23/9/2025, my lords, in criminal trial number 57 of 2021. So the appellant was convicted under section 22C and 25 of the Indian PS Act. And both the offenses, my lords, he was convicted for imprisonment for a period of 10 years and to pay a fine of 1 lakh each. And the sentence is to run concurrently, my lords. And my lords, there is no written FIR. This is a police case. So my lords, with your lordship permission, if I may kindly take your lordship to page number 1. That is the information recorded. On 22/2/2021, self-with party conducted random checking at Sring Lang Klang Junction, Zokota Road, and detained one vehicle, Alto 800 car, BR number AS so and so, driven by Abdul Mukit, son of so and so, resident of so and so, on a suspicious ground. On checking of the said vehicle after preparing grounds of belief, we recovered black polythene containing 4 brown boxes, contains 5 bundles. One bundle containing 10 black sachets and 1 sachet contains 200 small tablets, suspected to be methamphetamine. Total numbers 40,000 tablets. I seized the recovered items in the presence of reliable witnesses by preparing proper seizure memo. Seizure witness statement is also recorded. The vehicle driver Abdul Mukit, son of so and so, and the vehicle owner Abdul Hussein, son of so and so, of Badarkunda, Karimganj, were apprehended for further necessary action. Kept the seized articles in the NDNPS Malkana. The 2 persons were brought to you along with seized article after observing all necessary formalities at the spot as empowered by Government of Mizoram notification number so and so, date so and so, my lords. And the prosecution proposed as many as 5 witnesses, and they were examined. And then the 2 accused, my lords, the co-accused was acquitted, my lords. So they have defense evidence. And then charge was framed under section 22C, 29 and 29 of 25 and 29 of NDNPS Act. That is at page number 2, my lords. And then the appellant pleaded not guilty and claimed to be tried. And my lords, the evidence, the PW number 1, the seizing officer, is at page number 8, my lords. If I may read, my lords, I know the accused persons.
Read the relevant, what are your grounds of discipline?
Yes, my lords, if I may kindly direct to my lords, the grounds, my lords. Okay, my lords. My lords, my first ground is regarding violation of section 41, subsection 2 of the NDNPS Act, my lords.
Section
41, my lords.
41?
Yes. So, of the NDNPS Act. 41, subsection 2.
What does it say? And why do you say it is violated?
My lords, here, if I may read your lordships, power to issue warrant and authorization. That the first one, subsection 1, authorizes a magistrate to issue warrant of arrest. And the second, at point number 2, my lords, at subsection 2, the gazetted officer, officer, after recording his information received or grounds of belief, he may conduct search, seizure, and arrest, or he may depute or authorize any subordinate officer to act on his behalf, my lords. So, but what is the important point is that, my lords, any gazetted officer, if he receives any information,
It is not a case of information.
no, he receives information from his subordinate officer, my lords, and that's
He
the
says
seizing
that
officer.
I was checking the vehicle.
No, my lords, I
and
will come to that.
During checking something, I found the drugs.
No, my lords, I will come to that in his deposition, cross-examination, my lords. So, my lords, what I would like to point out is that, my lords, any gazetted officer, if he receives information from any person, or if he has reason to believe that any provision has been violated, he can act himself, my lords, or he can authorize his subordinate officer to act on his behalf. So that the authorization has been given to uh, SI Sila Sangliana, which is at page number 57, my lords. He authorized him to act on his behalf. But, my lords, the violation, what I would like to point out is that, my lords, that the gazetted officer did not taken down in writing the information he received. Not at all, my lords. The information was recorded by the other person, his subordinate officer, my lords.
As per the cross-examination.
No, my lords, on the basis of the documents exhibited as per available on records, my lords. There is no information recorded by the...
No. The sub-inspector who had arrested or who had made the seizure.
Yes, my lords.
Along with the seizure witness. In his cross-examination, he says that the car was detained by my subordinates.
Yes.
And they had informed me through telephone.
Yes.
And I proceeded to the place of occurrence. But
Yes.
you are saying that he not being a gazetted officer.
Okay.
Is he a gazetted officer?
Yes. SI Sila Sangliana is not the gazetted officer.
So since he is not a gazetted officer, he should have informed someone superior to him. And thereafter he should have, after the seizure and arrest, he should have informed someone superior than him.
Okay.
And since there is no record of any information being given to any superior gazetted officer, the entire arrest and seizure is not in accordance with law, cannot be used, or cannot be believed.
Yes.
For
And then-
conviction of the accused. Okay.
Section 41 and 42 is the mandatory provision, my lords. And the violation vitiates the trial. And then, my lords, after he received information from his colleagues, so the seizing officer, Sila Sangliana, and then he went to his superior officer, the officer in charge. He obtained authorization. But the information has not been reduced into writing by that officer in charge. My lords, by the submission is that regarding section 42 violation, so that officer, regarding the violation of NDNPS Act, there are 3 provisions which the officer can act upon. So, as per section 41 or section 42 or section 43, section 42 is the public places. There is no need to record information in writing. So it's in the public places. But in the present case, it's in the private place. That the vehicle in question involved is a private vehicle. So, my
The
lords,
vehicle may be private, but it is in a public place. You are being apprehended in a public place.
public places, my lords, it's like a hotel, and then it's
On
a
the
public
road.
place.
On the road.
No, on the road.
In a
That-
car,
I will come to that.
standing on the road.
I have one citation that the vehicle, the private vehicle plying on a public road cannot be termed as a public place. It's a private place, my lords. So, my lords, regarding section 42.
We are not deciding it today. Yes, Mr. Counsel, we are not deciding it today.
My lord,
We are hearing him so that we know what he's
Your
going
Lordship,
to talk
but
about.
the additional PP right now, she's having hearing matters at courtroom number 1. So
We are not deciding the matter today. We just want to know the grounds of his appeal.
yes,
And
Your
you will
Lordship.
have your turn to reply to it.
Okay, Your Lordship. Oblige, Your Lordship.
Okay? Yes.
And my
You
lords,
can make your notes if you have the time. You can make your notes so that you can assist her.
my lords, regarding section 42. So, section 42, any empowered officer. So, in a private place. So, after recording his information, he can conduct search, seizure, and arrest. And after sunset and before sunrise, he can, if he recorded his grounds of belief, he can conduct search and seizure. So, my lords, in the present case, as per section 42, my lords, so that the seizing officer, as per the document, he recorded the information which he received in writing. But, my lords, the cross-examination at page number 9, my lords. Cross-examination at page number 9, that is the seizing officer.
We've seen.
At the last para, my lords. So he said that, it is a fact that I prepared my information in writing under section 42(1) of NDNPS Act at 6:20 p.m. which was after recovery of the seized articles, and there was no indication that my superior had received the above mentioned information in writing.
Marker. Yes.
So, my lords, if the seizing officer, if he had acted as per section 42 of the NDNPS Act, so before proceeding to the place, before conducting search and seizures, he has to record his information in writing. But he accepted that he recorded the information at 6:20 p.m. after search, seizure, and recovery, my lords. And the information he recorded was
But
also...
he has to give it to the immediate official 72 hours prior, within 72 hours.
But my lords, he clearly accepted that his superior officer also did not receive it. He has to forward it and has to receive by the superior officer. That is the first ground, my lords. And my lords, my second ground is section 52A violation, my lords. My lords, as per section 52 of the Act, section 52A subsection 2, my lords, if I may read, my lords, where any narcotic drugs, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, controlled substances, or conveyances in any proceedings under this Act and make an application to any magistrate for the purpose of 1. Certifying the correctness of inventory so prepared, or taking in the presence of such magistrate photographs of such drugs, substances, or conveyances, and certifying such photographs as true, or allowing to draw representative samples of such drugs or substances in the presence of such magistrate, and certifying the correctness of any list of samples so drawn. Here, my lords, no sample was drawn in the presence of the magistrate, my lords. So, in this regard, if I may kindly...
No samples drawn?
No sample. Page 66, my lords. That is the exhibit P9. So, my lords, if we see at the reference case number, Champai PS case number 138 of 2020, date 12/12/2020 under section 21B. So, my lords, my case is Champai police case number 8 of 2021, my lords. No sample has drawn. This exhibit is different case, my lords.
Huh?
This case, the list of sample which is exhibit is not my case, my lords. It's a total different case, my lords.
What about page 65? Huh?
Page 65 also, my lords. Page 65 is inventory prepared in Champai PS case number 8 of 21. That is correct. But in this, my lords, in this inventory certified by the magistrate, that there are the mode of packing is only 4 books. Only 4 books. But how can the marks and numbers columns? How can 20 marks has been given? And my lords, in this regard also, my lords.
Marks?
Sorry, my lords?
What did you say?
Mode of packing, there are 4 books as per
Wrapping
inventory.
4.
Yes. But if we look into marks and numbers columns, 20 marks and numbers has been given.
Yes.
Now, my lords, regarding the FSL, page number 76, my lords. There are 20 numbers of exhibits have been examined. How many samples have been drawn from one box? So I think at least they have to draw 5 samples from one box.
So you are saying that the seized articles or the samples had not been sent for forensic
They have
because this page 66 shows that they were not marked properly.
yes,
You have got 20 samples where there are only 4 packets.
yes, my lord.
Samples, what is a sample drawn is not there. The police case number is different.
Yes,
And FSL inspects those
yes,
exhibits which are not related to this case to
Yes,
say
the-
that they are.
yes. So if sample is not drawn before magistrate, my lords,
And has
how
this
can
gone
they
with-
prove that?
Was this argued before the trial court?
My lords, the trial court clearly decided under section 52A, my lords.
Huh?
Section 52A.
The other part was not argued?
The trial court, yes, the trial court considered this matter, my lords, from page number 34.
This part was not put before the trial court. Any more grounds?
Yes, my lords. Maybe 4 or 5 more grounds, my lords.
What are those?
My lords, in this regard, what
Just
I'd like to
briefly,
say.
we are not hearing you full-fledged. Just
Okay,
briefly tell us, what is the next?
My lords, regarding, under section 52, my lords, no photographs has been taken before the magistrate, which is not also certified by
That will all
the
come under
magistrate.
52A.
My lords?
Those will all come under violation of 52A.
Yes, my lords.
And
Photographs. And then section 55, my lords. Safe custody of SA and samples, my lords. Safe custody of seized article and sample. No go down receipt. And And section 57 violation also, my lords. That is the report of arrest and seizure. And no, next ground is, my lords, non-production of the essay as well as samples before the trial court and not marked as material exhibit.
Okay.
And my lords, next ground, my last and humble submission will be, there is no conscious possession. There is no knowledge of the what is being kept inside that parcel, my lords.
So accused number 1 did not know,
My lords.
because it was the vehicle of accused number 2.
Yes, but you know, but my
And
lords,
he was only a driver who was taking the vehicle from one place to another.
as per his deposition, my lords, and his T1 he was going to Aizawl from I don't know
Some
the
place,
place. And then one non-visual person, but he don't know his name, and sent, and then saying that it was a motor spare part, and then he transported it free of cost, my lords.
This is not for the record. But tell us, why would someone who does not know who's driving a car, whose car is it, go and say, okay, deliver my spare part to that place, and he'll give the spare parts to this person, and this person, without knowing who that other fellow is, he will say, okay, I'll deliver it to your location, and he'll take the package. Huh?
That is always happen.
There's someone, anyone on the road comes and gives a package, take it to this place.
But my lords, the person who
This
sent.
is not a taxi. This is not a cab. This is not a parcel carrying vehicle. It is not a public vehicle.
Correct.
So any request made by a bystander saying that please deliver my package there, the vehicle will also take it, and this man will also give it. When it contains something like narcotics, why should the man who's giving him that narcotics take the risk? This man may run away. He may be a police officer.
Correct.
Why would he give someone?
But my lords, that the parcel, it was not concealed. It was carried openly, my lords.
It was carried in between the front and the back
Front
seat,
and the back
covered by a
seat.
betel nut bag. That is concealing.
But my lords, what has confusing me is that, as per the position of the witnesses, prosecution witnesses, so it was recovered from under the bonnet, from in the front and back seat. That the bonnet cover is the front.
What kind of a vehicle was it?
It is a car. Alto car.
No, they don't say bonnet. No one says bonnet.
Here, PW number, page number 10, my lords.
Page number?
10.
10.
So the word starts from sixth line. The word starts with to be more specific. The seized articles were kept inside one polythene and packed in 4 brown box, and seized articles were kept between the. This is correct, my lords. That the seizing officer.
No, page number 12, the other seizure witness says.
Yes.
Kept inside the bonnet cover of
Yes.
between the front rear seat of the vehicle.
I don't know, is this a
But how can someone keep a Ereka bag on top of the bonnet? How will he drive the vehicle? The TCR is here. TCR is here.
TCR is, yes, called, my lords.
TCR, why don't you look at the statement given in your in that vernacular? Perhaps it will be when he was making a statement, he made a mistake. Also the person, the I also says so, yes. Page 15 also he says bonnet. No, DW1 says it was in the seat, between the seat. The statement is there or not? Huh?
The statement purported to be reported by the SIO.
No. We are saying during the trial, is it recorded in English or was it no, they had made the statements in vernacular and then it was translated, or is it recorded in English itself by the learned trial court itself translating it?
It is recorded in English.
Same that bonnet part is there.
Yes, my lord.
That bonnet part is there.
Yes, my lord.
No, it's okay. You say it is there, we believe you. Yes, when shall we have it? Thursday
Your Lordship, she's.
or next Tuesday?
Your Lordship, any preferable date?
It have it on Tuesday.
My lord.
Hmm?
My lord.
Mr. Swenson, counsel appearing for the appellant. The learned APP is stated to be before another court. According to releases matter again on Tuesday. Yes. Please.
Give your oblige, Your Lordship.
Yes, sir.
I'm so sorry. Sorry for inconvenience. I'm in item number 5. I came late because because my son is seriously sick. That's why I cannot be able to reach in time. When I reached there, my learned friend was already standing. He just passed.
Which number?
Item number
9
5.
of?
Part 2.
Part 2.
Part 2, item number 5, yes.
You want to take it up? You want us to take it up?
Yeah, if possible.
Where is the other side? You are there?
But the respondent number 2 has already left, Your Lordship.
No, number 2 had already left, but my lord, we are not claiming any relief from number 2. So main relief claim is from number 1. This respondent number 1. So if possible.
Yes.
Yes, my lord. This RFA arises out of the dismissal of the civil suit in civil suit number 37 of 2021 by the Senior Civil Judge 2, ISO. The appellants were the plaintiff in the civil suit, and I'm representing the appellants. So the learned trial court dismissed the prayers of the plaintiff. There are two major prayers. It was dismissed in contradiction to its own finding. Both the prayers are to, number one, to hold the agreements valid and binding upon the parties. Actually, appellants number 1 and 2 and respondent number 1. And 4 other they have executed an agreement. 4 other peoples have not joined us. So his findings was the agreement number 1, to hold the agreement valid and binding upon the parties. The learned trial court holds it a valid and binding among the parties. But for enforcement, it refuses to enforce the agreement because the main reason, the main contentions of the trial court was some parties have breached the terms and conditions of the agreement. If my lord can see the agreement, agreement at page number 43. 43A is the English translation. If my lord permits, I will read it out. We, in respect of the sale of the lands belonging to Sri Lalthengliana. Sri Lalthengliana is the respondent number 2, and Smith Lalthamwani. Lalthamwani is the sister of respondent number 2.
Where is the agreement again?
43A. Page 43A. Yeah, number 1 is continue to act jointly in good faith and with sincere efforts. Number 2, the following persons are appointed to pursue the office files. Pironguri Lalthanpari. Thanpari is the respondent number 1, and Pirin Siami, she is the appellant number 1. Number 3, no persons other than those appointed shall pursue the office files. Number 4, any amount expended, including any anticipated expenditure, shall be reimbursed from our shares in case of huge amount. And whatever balance amounts left shall be equally distributed among us. The under signatories agree to these terms and shall not raise difficulties on our part. This is the agreement of 2016. Then, accordingly, the land was acquired by railway at Sairang, railway. Then the owner of the land, respondent number 2, he executed the power of attorney on behalf of respondent number 1. Then all the money, all the compensation money was credited to respondent number 1. Then after that, respondent number 1, by her own choice, paid some amount to other parties according to her will. Then when the appellants, when they claim to give her out all the money, their shares, equal shares, she refused it. Then the appellants went to the criminal court. Then the criminal court findings. According to the criminal court, he entrusted the police, OC of Aizawl Police Station, to take the investigation. Then in that statement, plaintiff number 1, one of the party who is not joining us, he has breached the contract. Contract means the terms of agreement.
Which agreement?
This agreement.
Which term? Which term has been breached?
Oh, they said that this one, number 3, no persons other than those appointed shall pursue the office file. Because that person, that one, he went to the revenue office. Then he inquired about those things. All the how did they pursue, all the how that the file was there. So Because of that, her contention was that that person had breached the agreement. Therefore, the learned trial court's finding was that this agreement is valid and binding upon all the parties. But some parties have breached the terms of agreement. Therefore, we cannot enforce it. That was the conclusion.
No, you had a agreement for sale of land.
Sale of land. For intention to sell of land.
Agreement of intention for sale of land.
Yes.
That land has been acquired by the railways.
Railways, yes.
Land is not there.
Yes.
Some compensation for the land has come.
Some compensation was paid.
You authorize some other party to take up the process of that land acquisition and everything. That is the power of attorney, is it not? You executed a power of attorney authorizing someone to take the money.
Power of attorney was executed between the respondent number 1 and respondent number 2. But respondent number 1, before the respondent
You wanted to buy the land.
Huh?
You wanted to buy the land.
No.
You were the seller.
Yeah, actually, appellants, both the appellants, 4 persons and respondent number 1, they have jointly made this agreement. If we can sell the land, then all our shares will be divided equally. Then we have to share it. That was the agreement. Then the compensation amount was paid in the account of respondent number 1. But she refused
Just a minute.
share it.
You are Lalrin Sangi. You are one of the signatories. You say that you will act jointly in good faith. Office files will be pursued by so and so. No one shall pursue the office files. Amount expended, including any anticipated expenditure, shall be reimbursed from our shares. So this is regarding the sale of land.
Yes.
Then that land was, were you one of the owners? No.
The owner is the respondent number 2.
Who are you?
I'm the appellant number 1.
Appellant is how he is connected to the land. He wants to buy it, he wants to sell it, he wants to do what?
No. As a commissioner, we say that these people are land commissioner. You would
get a share of the money if the land is sold.
Yes.
You were working on commission in helping the sale of land. Yes.
Yes.
Now that land is not sold.
Sold means
it is acquired.
Acquired. Yeah.
Where is your agreement? Your agreement was if only it is sold.
Agreement.
Had it been sold, you would have had your commission. But it is not sold. Or am I understanding differently? I may not be understanding correctly. You have to correct me if there is some other line of thought, you can say so. It's not that I will impose it, but tell me this. There is no sale of land.
My lord, sale of land and commission, they use it in a single word. The term refers to same thing.
No, we are not understanding your status in the deal. There was an agreement in respect of the sale of land of so-and-so persons.
Yes.
To whomsoever it is sold, you will get a commission because you are trying to help them sell the land, you are doing whatever other work is there. Yes? Now this land is not sold.
This land has already been acquired.
It is not sold. You have nothing to do in the matter. Land has been acquired by the railways. Yes? Whosoever was the owner will get the money. Where is the sale? Who are the other parties?
The other parties are on page 43.
Lalthanpari was also with you.
Panel Soma is not with us. Raungur is not with us. Thanpari is respondent number 1. Johnson is appellant number 2.
Sir, who are the opposite parties? Lalthanpari and Lalthan Who is Lalthanpari? Is it the down
Lalthanpari is respondent number 1. Respondent number
Who
one.
was she in the agreement?
Actually, they were forming a group. For credit of the money to the account, she gave her account to credit the money.
Where is that agreement of that?
In the number 4 is power of attorney, my lord. In in paragraph number 1, to negotiate on terms for and to agree to and enter into and conclude any agreement or sale and sell my land covered by house past descender. So the term sale is always used here. Whether railway has taken it or whether it was purchased by somebody. My contention is, my lord, if some parties breach the agreement, the agreement will be still binding among the non-breaching parties, according to Indian Contract Act.
So what is that contract? What is the agreement? The agreement is
Agreement is a contract.
that you want to act jointly and in good faith and with sincere effort. Office files for the purpose of sale will be undertaken by 3 persons. No other person shall pursue the office files. Any amount expended, including anticipated expenditure, shall be reimbursed from our shares, and whatever balance amount left shall be equally distributed among us. So, whatever money you get out of the land, you all should have shared the money.
Yes.
But this, the second person, Lalthan Pari, did not do it.
Yeah, she did not comply with this.
She did not give you the
money.
She did not give you the shares.
Yes.
So where is Lalthan Pari's signature here?
First line, third one.
First line.
Third one, Thanpar.
Thanpari.
Yes, Thanpar, yes.
She had signed it. Then the when the land was about to be acquired, the owner of the land relied upon Lalthan Pari.
Yes, correct.
That I will get 150 lakhs, and Lalthan Pari and Lalthan Niana will manage, and Lalthan Pari will share more amount to Lalthan Niana. Then, now who violated the agreement?
He is not joining us.
Who violated it? What is his name?
In this agreement, Zothan Buanga.
Huh?
Zothan Buanga.
Last line first.
Yeah, last line, yes, first one.
So he violated the agreement.
Yes.
Now the trial court says that the agreement could have been enforced, but because one of the persons therein had violated the terms, it becomes enforceable or not enforceable
Yes.
against everybody.
Yes, correct, yes.
That is what you are saying.
Yeah, yeah, that was his finding.
So that is what you are saying is wrong. It should be enforceable for the others who have not violated the terms and conditions. That is your case?
Yes.
Where is that part? That it will not be done?
My lord, in page number 8, I have said that. What some grounds? Page number 8. That the appellants respectfully submit that the impugned order is
You were plaintiff number 1. You are the plaintiff number 1. You are the plaintiff number 1 in the suit.
Plaintiff number 1 is Zothan Buanga. Plaintiff number 1 is Zothan Buanga. 2 and 3.
You are 2 and 3.
Yes. Plaintiff number 1 has not joined us.
And defendant number 2 is the owner.
Yes, correct. Landowner.
Now, once you breach you are plaintiff number 1 and plaintiff number 2 and plaintiff number 3, when they filed a suit, 1 and 3 breached the contract terms. Yes? Now, you are only appealing for 2. Plaintiff number 2 is the appellant here, yes?
Yes, yes.
2 and 3.
2 and 3.
3 has also breached the contract.
3, my lord, in that case. 3, in the statement, in the police, recorded by the police, the plaintiff number 1 and plaintiff number 3, they were imputed breach of that agreement. But actually, under Section 25 of Indian Evidence Act, any admission made before the police is not valid. It should not be taken as an evidence. So, in a civil court, in a trial court, depositions where, when we look at the depositions, only plaintiff number 1 himself admitted he had breached, but not plaintiff number 3. All the appellants and respondents, they have not imputed the appellant number 2 to having breach of the contract. Only plaintiff number 1.
You want the agreement between the plaintiff number 1, 2, and 3 and the defendant number 1 to be executed.
Yes.
So what you are saying that whatever amount has been given by the defendant number 2 to the defendant number 1 needs to be distributed between plaintiff 1, 2, and 3 in terms with the agreement.
Yes, correct.
That is what you are trying to say.
Yes, correct.
And the learned trial court has found that 1 and 3 have already violated the terms and conditions of the agreement. Therefore, they are not entitled to relief.
Yes.
But there is no reason given why plaintiff number 2 is disentitled. Because she did not violate any terms.
Yeah, yes, my lord.
And 3, what has 3 done? Yes, madam.
Yes, Your Lordship. It seems that the appellants built their entire case based on the agreement that is 9/6/2016. So if we look into the agreement, we can, if Your Lordship turn to page 43A, it starts with, we in respect of the sale of the lands belonging to Sri Lal Klingliana, which is the respondent number 2 here, and Srimati Lal Khamwani, which is not made a party in this appeal, hereby agree to take continued steps under the following terms, under which clauses are given. So the parties cannot select clauses which are favorable to them while also ignoring the clauses which
impose obligations upon them. So based on the evidence, we can see that a breach was committed by one of the party, one of the signatory to the agreement. So the Learned Council has stated, it is a joint agreement. So it is an inseverable agreement. You cannot,
Madam, if you stay in a hostel
yes,
and one person refuses to eat
yes.
the dinner, will everybody be denied dinner?
There is not an agreement there, Your
No,
Your
the
Lordship.
agreement,
in
one
that.
person breached the agreement by visiting the office.
Yes.
Plaintiff number 1. Plaintiff number 2 and 3, there is nothing in the findings saying that they had also breached the agreement.
But Your Lordship, this is a common undertaking because when
Could
we
be.
look,
we all agree that we will share it like this. One person acts as a bad man. He does not do it. He will be out of the agreement. The agreement will be null and void against him. Why will it be null and void against every other person?
because there is a written agreement here in this case, Your
So
Lordship.
one of them says that I will not follow it. Does everything come down? He will be out of the agreement. He cannot claim a relief. Therefore, plaintiff number 1 may not be able to claim a relief if we believe the statements made before the police.
Yes.
But in any case, how can everybody be denied?
Because, Your Lordship, it does not create a separate obligation. The agreement does not create separate obligation for each signatory.
Then tomorrow, let us see it this way. Suppose this, you are appearing for Lalthanpari.
Respondent number 1, yes, Your Lordship.
Lalthanpari.
Yes, let her read.
Now this Lalthanpari, she violated the agreement. Can she take advantage of her own wrong?
No.
She has gone and joined another person saying that I will help you in this this acquisition process. Give me my share, this much, this much, this much.
Yes.
Lalthanpari has violated it.
No, Your
Now she's
Lordship,
taking advantage of her own violation,
but if
saying
we,
that no, he has also violated. How does his violation
because it has become infructuous, Your Lordship, it cannot continue anymore after there has been a breach.
when it came into existence by everybody's meeting of mind, it has to go by everybody's meeting of mind. Can it be because one person says I am not agreeing to it? He's out.
And also,
Only he'll be out.
yes.
How can other persons who were acting dedicatedly without breaching any terms of the contract, how can they be punished?
Because, Your Lordship, from my point of argument, it is a common undertaking, a collective undertaking. So it affects the agreement itself. It defeats the purpose of the agreement itself when one party breaches
then
it.
there'll be a situation, madam, where two persons will say that let us all get to an agreement. You breach one term, I'll take the profit and run away, then you breach some term. And then the agreement is gone.
Yes.
Can it be so?
Not in the example you have given, but here it is different, Your Lordship.
This
Because,
Lalthanpari was supposed to pursue
yes,
the
but she was
office files.
prevented. She was prevented to perform
So
her duty.
Lalthanpari, she was supposed to pursue the matter.
Yes.
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 When she was prevented, she did not make a complaint.
She
Did she make a complaint that you are preventing me, so I'm out of the agreement? She does not say so. Then she does not make a police complaint. She does not make a civil suit that I am the only person who is supposed to take care of the office files. Why is he disturbing me? There is no complaint, nothing. Then she simply goes and joins someone else and says, okay, now you are going for a acquisition. You give me this share, I'll help you out.
But Your Lordship, if
She
we
has
look into
violated
the
it.
agreement, the agreement does not create any enforceable right to the acquisition
You have not
compensation.
challenged issue number 1 that the agreement is enforceable. You have not made any challenge, have you?
The
Did you
regarding,
make a counterclaim?
no, Your Lordship,
Have you made a cross appeal?
no.
Then you have agreed to the finding of the trial court that it is an enforceable agreement. You are defending the order of the learned learned trial court, saying that look, he is correct when he says that if one person violates, everybody is free. Yes?
Yes.
So how can you now argue that no, this enforceability is wrong? You
The-
never filed a cross appeal. You have admitted it. You have accepted it.
Yes, because
Just
your
fine.
lordship, the question whether a valid agreement is in existence is not the issue here, that is admitted, that a valid agreement existed. But the real issue is whether the terms of the agreement has been violated
By whom?
by the signatories of the agreement.
One of them violates it.
Yes,
Suit qua him is dismissed.
but
He is not entitled to any relief since he has violated. How can the others be held responsible?
because it is a joint agreement and it binds all of them, your lordship.
Madam, let us again think about it. 6 people sit down. Okay, now we have got this politics things. So many parties come together to swear in and form the government. Yes? One party says, I'm out. Will it affect everybody? No, if the majority is there, there is no effect. Yes?
If they had executed an agreement as such as this.
So one of
then-
them violates, one of them makes a breach.
Yes.
Suppose this man who had breached this plaintiff number 1. Now plaintiff number 1, if he had been in the position of the defendant number 1, if he had taken the money, would the defendant number 1 still say that I cannot enforce the agreement? Or will the defendant say that no, I have a right to that agreement, my right is created? He will take the money, he will run away, and then he will say no agreement.
That I cannot tell, I cannot say.
So therefore, even in this case, what we are finding is violation of a joint agreement between many parties. One of them breaks it.
Yes.
How can it affect everybody?
But if we look into the
If
agreement,
it
your
had been
lordship-
2 parties, party number 1, party number 2, they make an agreement, this party says, no, I am violating it. Then he cannot come for enforcement
Yes,
because he has violated it.
yes,
But here are many people. Yes?
yes.
One of them says, I will not do my part. How can it take away the rights of the other persons? When he has not made a complaint, the person now who's trying to resign from that contract, he has not made a complaint that it was violated.
But
While taking the power of attorney or while taking any other step, did she inform this Lalthanpuri? Did that person inform that, look, Mr. Zothang Buanga has violated the agreement? I am no longer there with you. I will take my own road. Thank you. I am going.
not that I'm aware
That was not
of.
done. That is not there in the evidence. That is not there in the written statement.
But your lordship, if we look into the agreement, that it does not state that the signatories purchase any portion of the land. They are not even the owners of the land. And it does not assign the compensation payable by the government as well. So it does not,
Whatever has happened, now this sale of land, his argument is whether it is sale of land or acquisition of land.
so how
It is a
will,
transfer of land.
on what basis will the share be made? Because it is not, the agreement
Whatever
itself
balance
is not
amount left shall be equally distributed amongst us.
a balance left from what? From where?
Amount expended, including anticipated expenditure, shall be reimbursed from our shares. So
That the source
the
of money
defendant
is
number
not
1 will say
indicated.
this much is what I got. This much I have spent. Rest this much remains.
There
Because
is,
it is in your knowledge,
yes,
it is in the knowledge of the defendant number 1, what is the expenditure made? A fact which is in her knowledge, she will prove it. She has to prove it. So she will say this is the expenditure. The rest of the amount has to be divided. It may not, Zothang Buanga may not have the right to enforce the agreement because admittedly he has violated it and he is not here in appeal before us. But so far as the plaintiff or the appellant, plaintiff number 2 or 2 and 3, you are here for only 2.
2 and 3.
but
2 and 3.
Appellants are 2.
Appellant 1 and 2.
1 and
Appellants
2. The appellants are here.
yes,
Nothing against them. Why should they be denied?
they are not denied. In fact, they were given 50 lakhs each. Appellant
It has to be
number,
equally
Equally, they were given upon based on the agreement itself, because the agreement does not specifically indicate the source of money. It does not indicate,
So how do you say it is equally?
because
The
like
moment you have given them a share, the agreement is enforceable against them, qua them. You
Also-
admit it.
portion, and also look into the if we look into the memo of appeal, the prayer portion, Your Lordship,
What does it say?
prayer portion subclause B. Declare and hold that the appellant number 2 has not breached the agreement titled in remna dated 9/6/2016.
Appellant number 2 has not.
So what about appellant number 1?
Appellant number 1 in any case, No, his C will,
And subclause D, based on what? Amounting to a total sum. These calculations are based on what?
that if the amount, if you are trying to, at page number 11.
My lord, if you look at page 114, this is the deposition of respondent number 1. Page number 114. Number 17. It is correct to suggest that I did not distribute the shares of compensation as per Exhibit 1. This is the agreement. Because it is my belief that some parties have breached the agreement.
Some party will breach the agreement and you will not, and you will then go about breaching it against everybody. Is that equity?
Then, my lord, point number 18. It is correct to suggest that as per Exhibit 1, apart from the shares of the defendant number 2, landowner, the remaining shares was to be divided equally among signatories except the VCP. Defendant number 2, he wants only 150 lakhs, according to the agreement.
According to the
Agreement between respondent 1 and 2.
Defendant 1 and 2.
Yeah.
So defendant number 1's witness is also cross-examined by the defendant number 2.
According to deed of agreement executed between respondent 1 and 2 in page 46. Second para.
Page 40?
Page 46A. This is English translation. Aila Chingliana.
Okay, we have seen that. Show us the law that if there is a joint agreement between parties, violation by any one man of the agreement will break down the entire agreement for all the parties.
Under the
There are many
doctrine of
signatories to an agreement. One person breaches the terms and conditions, and the entire agreement will come. No one else can enforce it against each other. Show us that law.
under the doctrine of approbation and reprobation, Your Lordship, that's the same instrument cannot be accepted and rejected. So if we look into the agreement, clause 2 appointed 3 persons, namely Pir Ronguri Pilal Thanpari, which is the appellant number 1 here, and Pirin Siami. They were appointed to pursue the office files. And coming to clause 3, no persons other than those appointed shall pursue the office files. That is clearly written. And under clause 5, it is written, all signatories agreed to these terms and undertook not to raise difficulties. So they all agreed to this. So it binds all of them. So when party breaches, commits the breach, it affects the entire agreement itself, Your Lordship.
Show us that law. We can show you the law against it.
I can provide one ruling, 2 rulings in fact.
2?
Bank of India versus K. Mohandas and others. This is
What does it say? You have any judgments? Any citations?
No, my lord.
Huh?
And another that is Rajasthan State Industrial Development and Investment Corporation Limited versus Diamond and Gem Development Corporation Limited. It is here.
Which part of this? Which part of this judgment are you?
In page number coming to Bank of India versus K. Mohandas, page number 11, paragraph number 28 and paragraph number 30.
Paragraph number?
28 and paragraph number 30. So, should I read it aloud, Your Lordship? Paragraph number 28, the true construction of a contract must depend upon the import of the words used and not upon what the parties choose to say afterwards. Nor does subsequent conduct of the parties in the performance of the contract affect the true effect of the clear and unambiguous words used in the contract. The intention of the parties must be ascertained from the language they have used, considered in the light of the surrounding circumstances and the object of the contract. The nature and purpose of the contract is an important guide in ascertaining the intention of the parties. And in paragraph number 30, it is written, in Ganga Saran versus Firm Ram Charan Ram Gopal, a 4-judge bench of this court stated, since the true construction of an agreement must depend upon the import of the words used and not upon what the parties choose to say afterwards, it is unnecessary to refer to what the parties have said about it. So, and the other ruling, that is Rajasthan State Industrial Development and Investment Corporation Limited versus Diamond and Gem Development Corporation Limited, I would like Your Lordship to kindly turn to page number 9 and 10. That is paragraph number 16. A party cannot claim anything more than what is covered by the terms of contract, for the reason that contract is a transaction between the 2 parties and has been entered into with open eyes and understanding the nature of contract. Thus, contract being a creature of an agreement between 2 or more parties has to be interpreted giving literal meanings unless there is some ambiguity therein. The contract is to be interpreted giving the actual meaning to the words contained in the contract, and it is not permissible for the court to make a new contract. However, is reasonable. If the parties have not made it themselves, it is to be interpreted in such a way that its terms may not be varied. The contract has to be interpreted without giving any outside aid.
All these are agreed to, madam. How does it affect your case?
Because
What is the point you're trying to prove?
The point is that if we look into the agreement, it has, like I said, it is divided into 5 clauses, and they have all signed and they have all stated that they shall agree to these terms and shall not raise difficulties on our part. This is not signed only by FZO Thanbuanga. They have, the other parties have also agreed
So
to
show us that they were party in creating difficulties. That the appellant number 1 and 2 has created some difficulty. Show us.
The appellant 1 and 2 directly do not create that. It is the person, FZO Thanbuanga. However, since all are parties to the agreement itself, it binds all of them because it is a joint agreement and it is
So
inseverable, Your
instead of
Lordship.
showing me this law, which does not answer the query from the court,
Also, Your Lordship, the Contract Act is not wholly adopted here. Therefore,
that was not the reason why it has been rejected.
so the
You are depending on the contract to say that once the breach is, once there's a
Yes.
breach, everything will go.
the agreement, it has to be determined by the terms of the agreement
True.
itself and
So-
by the conduct of the
So
parties.
where does it say that if one person violates it, everybody will suffer? Where is that? Why are we reading it into the contract?
Because it is,
The
these are,
judgment that you have shown us, the judgment that you have shown us just now,
yes,
it says that we cannot take aid of anything else. Yes?
yes, yes.
Now, this contract does not say that even if one man violates, everybody will suffer. That is not there. How can we read it into it?
But is it enough to reverse the decree, Your Lordship? That is the question. Because
Huh?
there is no perversity and the findings are based on pure findings of fact
no,
established.
the finding that one person violates the agreement, everybody will suffer. He has simply assumed it. The defendant plaintiff number 1 made a statement before the police that he went to the office.
Yes,
He interfered with the file.
yes,
And you, in your written statement, you say that they stole the file and therefore you had to reapply and all this
Yes.
trouble came up. Yes?
Yes.
Are we understanding correctly?
Yes.
So this is because of plaintiff number 1. So
Yes.
plaintiff number 1, since he has violated a breach of, since he has breached the contract, he is not entitled to any relief, let us assume, for the time being. Although there is no proof that he has breached it. 2 and 3, they did not commit any breach. So show us one judgment that if there is an agreement between more than 2 persons
yes.
and one person violates any of the terms and contract of the condition of the contract, then the entire contract becomes unenforceable. That is the judgment you have to show us. That one person violates, everybody goes. One pillar falls, the whole building falls. That is what you have to show us. And you have to show us that violation by one person will not entail a penalty on us. Even if we assume that there is a violation, why should we suffer? We were good people. We had good conscience. The defendant number 1, she goes and makes an agreement with someone else without informing us. She has breached the contract. So now she must suffer. She must give us what is entitled to us. She cannot claim a benefit of her own wrong. That is what you have to show us.
And another question, Your Lordship. Is this even a contract? That is the question. Because
You did not-
every agreement,
Madam, you have not challenged the findings of the learned trial court, have you?
no, Your Lordship.
Then how can you raise the question here? In your evidence, you have stated that yes, they are entitled. Yes, this is a contract. I signed a contract. I signed the agreement.
Yes.
I did this. I did this. So at that point of time, you were not there to assist the defendant number 1. So she made her own mistakes. You cannot correct them in appeal because this is not a writ appeal. Is it not? You will not take those grounds which were not there before the learned trial court or what has been settled by the learned trial court unless you challenge it. We will not answer in your favor.
Correct.
So that part, that is what was to be done before the trial court, saying that there is no contract. This is not an agreement. How is this an agreement? We had all signed the papers. It was simply word of whatever.
Yes.
Cannot be enforced. But the court holds that it can be enforced. It's an enforceable contract. You are not challenging it. Gone. Now, the court says it cannot be enforced only because one person violated it, or maybe two persons. You have to show us the law that even if one person violates it, nothing can be done. The entire contract goes. And he has to show us that 5 people are supposed to do something. One of them does not do it. Others are all ready to do it or have not breached the contract. Why should it go? It's then either of you will get a relief.
My lord, if you look at page number 10,
Huh?
page number 10, F.
10 of what?
In this regard, the appellants submit that the agreement is a joint agreement within the meaning of section 42,
Where are you reading page number 10?
page number 10.
Which line?
1, 2, 3, 4, 5, 6, 7, 8, 9. 9, from 9 I will read. In this regard,
Just a minute.
in this regard, the appellants submit that the agreement is a joint agreement within the meaning of section 42 of the Indian Contract Act 1872 to fulfill the promise, and that the refusal or breach of the agreement is governed by section 39 of the said act, wherein the plaintiff number 1 himself put an end to the agreement in remna, and he can no longer claim any right or benefit
This is what
thereunder.
we are saying. One will
Further,
go.
The agreement is binding and valid, enforceable within the meaning of section 10 of the act, and under section 37 of the act, the non-breaching parties are entitled to.
You will have to address us, madam, on section 10 and section 37 of the act. To show that yes, contract act है यहाँ पे. Court master, contract act. Is it there? No. What is 37? Parties to a contract must either perform or offer to perform their respective promises unless such performance is dispensed with. Promises bind the representatives and so and so. And what is section 10? What agreements are contracts and what is 39? See, G 44, section 44. When two or more persons have made a joint promise, the release of one such joint promisors by the promisee does not discharge the other joint promisor or joint promisors, neither does it free the joint promisors so released from responsibility to the other joint promisors or joint promises. You all made a promise that we will act together and we will share the money. One of them is released because he breached. Does it take away your promise made? 44 says no. You made a promise, you will keep it with the others. Specific case, appellant number 1 and 2, they have not violated anything. Then your joint promise, where does it go? Now you understand what is the law we are trying to find out.
Understood, yes.
If
Your
you can
Lordship.
show us that breach by one makes the entire contract void
Yes.
in case of a joint agreement, the entire agreement goes. We'll quote the law, we'll dismiss the appeal. If he can show that one person violates, the others still have to maintain their relationship unless it is broken, unless you agree to give up the agreement. Then he wins the case. Simple point. None of you have raised a grievance that the agreement is not enforceable. You have not made an appeal. He agrees to the trial court saying that yes, it is enforceable. Very good.
Yes.
And in the given circumstance, is it enforceable or not is what you have to show us. Then we can give you a judgment.
Understood.
Yes, sir.
Yes, my lord, if you
When
look
we
at-
say yes, sir, we are not asking you to argue. We are asking you to give us some citation. Huh?
my lord,
Some reading has to be done. Homework.
the trial court has granted a relief to the defendants, which they have not prayed for.
What relief?
In operative portion, in order.
That they can go into an agreement with someone else.
Yes, they can.
That is a different issue. Even setting it aside is not helping you.
Yes, yes.
Will it help you if you set aside that
no,
part?
no,
It is not helping you. Why? It may be wrong in so many ways,
That's correct, my lord.
but you have to find out where is the shoe pinching the foot and correct that part of the shoe. Is it not? Your share is not being given to you. That is your trouble.
Yes, my lord.
Show us that the agreement, when it is by 5 persons, violation by 1 is not going to affect the rights and liabilities of other 4 persons unless it is of a nature that violation by 1 has to make the entire agreement go. There is no other possibility. Suppose there is an agreement that you will all do business. You will all put in 5,000 each. And you are going to the government to say that, okay, give us this contract, we have put in 5,000 each and we need to take the contract. One of them says, I will not give my 5,000. Government value is 25,000. You don't have 25,000 now. The agreement has to necessarily fail. Is it not? Or you have to file a suit saying that this man should give his 5,000 so that we can go ahead with the government contract. Is it not? One violation will not make everybody else fail. Find out the law. Tell us when. Next Thursday.
Next Thursday. Yes, Your Lordship. That will do. Yes, next Thursday.
Next Thursday.
Yes.
Yes. Call this matter again on next Thursday. Huh? I'm not passing any orders. Just call it up again on next Thursday. Put it up. And if you can come up, anyone of you can come up with the proper arguments, proper law, we'll dispose it of.
Right.
Either which ways.
Chop pledge.
Aye. Heard Mr. So-and-so and Miss So-and-so. List the matter again on, what is Thursday? 13th. 13th of August, 2026. Give us the appropriate law. We'll pass whatever orders we. Thank you.